Okay, I think we're going to go ahead and get started. Good afternoon, and thank you for joining us for this special COVID-19 webinar, Navigating Landlord and Tenant Relations and General Real Estate Issues. It's hosted today by the Birmingham Business Alliance and Maynard Cooper and Gail, as well as the Birmingham Regional Economic Development Alliance, which is a network of economic development professionals and organizations throughout our 7-county region. I'm Lauren Cooper. I'm Vice President of Communications for the Birmingham Business Alliance, or the BBA, and I'll be moderating today. Maynard Cooper and the BBA and all of our economic development allies in the surrounding counties have been working one-on-one with impacted businesses during the pandemic. And we've established response teams and task forces to answer questions and address issues local businesses are facing during this really challenging time. From the BBA perspective, we've connected with nearly 600 investors in our organization that we've identified as small and mid-sized businesses that are most likely to be impacted by the pandemic. We've offered support and connected them to the resources that they need. And we've provided a lot of guidance to a lot of companies on the SBA loan programs. In these conversations we and our allies and Maynard Cooper as well, have with these businesses, we receive a lot of questions that are legal in nature, and some of them we can't answer ourselves. So we turn to our partners at Maynard Cooper, who have been working with their clients and small businesses. In looking to them for their expertise, we discussed partnering on several webinars that address some of the more frequently asked questions that we were getting, and to help us understand what will be most important as we return to work. A lot of the questions were around employment issues, which was covered in a previous webinar, and a lot of other questions were around real estate, which is the focus of the webinar today. We did record our webinar that covered employment issues, and it can be found on the Birmingham Business Alliance website on the COVID-19 resource page. A little on the structure of this meeting. We have 5 important topics to discuss and 4 attorneys from Maynard Cooper. We'll give them each about 10 minutes to address their topic and cover some frequently asked questions that we've gotten and a few that we gathered from the audience as well, in the hopes of wrapping up by about 3 p.m. If any of our attendees need clarification on something or have a follow-up question on what was discussed today, you can visit the COVID-19 resource page on our website, on the BBA's website, and click on the Ask a Question tab. I'd like to give a brief background on our speakers today. First, we have with us Sarah Glover. She's a shareholder in Maynard Cooper's cybersecurity and data privacy practice. In her practice, Sarah focuses on cybersecurity compliance and risk assessments, incident response, compliance, and vendor management. As a member of the firm's coronavirus task force, she's been studying the impact of the pandemic on vendor and other contracts, including the operation of force majeure clauses. Sarah will start us off today discussing how force majeure clauses might operate in the wake of COVID-19, and then we'll conclude today's presentation with the cybersecurity update and the threats her clients are facing during this time. Welcome, Sarah. Next, Mel McElroy is a shareholder in the firm's real estate practice and represents developers and investors in all aspects of real estate, including financing, development, acquisitions, and dispositions of commercial property, ranging from shopping centers, mixed-use developments, office buildings, and industrial sites to undeveloped land. Thank you for joining us, Mel.
You're welcome.
His partner, Brad Siegel, has broad experience representing landlords and tenants in all types of commercial real estate matters. He also represents buyers, sellers, developers, and investors in all aspects of real estate, including acquisitions, dispositions, leasing, finance, partnerships, and joint ventures. Welcome, Brad.
Thank you.
Finally, Lee Shepard, also a shareholder in Maynard Cooper's real estate practice, is joining us. While Lee also has a broad commercial real estate practice representing clients on a wide range of matters, he spends a significant amount of time advising clients in the commercial construction industry, including owners, developers, and contractors in connection with contract negotiations, contract administration, and project management. Glad to have you with us, Lee.
Glad to be here.
And with that, I'm going to turn the program over to our experts. First, I'm going to ask Sarah Glover to discuss the force majeure clauses.
Thank you. Thanks for having us here today. Hope everyone's doing well. One of the questions that we have been getting a lot recently from clients is whether force majeure is an option if the current crisis has rendered performance under a contract difficult. Generally speaking, force majeure clauses in contracts outline certain types of events that are considered to be beyond a party's reasonable control, that a party did not cause, and that were generally unforeseeable, and that might prevent a party from being able to perform under a contract. Depending on how the language in the provision is written, the party might be excused from performance, or the party might be able to delay performance for a certain amount of time. There are a few things that I want to highlight about force majeure clauses, generally speaking, just some important things to keep in mind as you're navigating issues related to performance and contracts right now. The first thing is that, in a sense, no two force majeure clauses are exactly alike. Having a force majeure clause has become boilerplate in contracts, but as with other contract matters, the specific language used is critical in terms of outlining the parties' rights and obligations. The second thing that I want folks to keep in mind is that force majeure clauses might buy you time in terms of delaying performance, but they typically won't nullify the entire contract. So at some point, you're going to have to either reform the contract because of current circumstances, or you're going to have to figure out a way to achieve performance. And then the third thing that I want to highlight is that, the current environment is really unprecedented in a lot of ways. We might see some new precedent coming out of courts as a result of both the health and economic impact of the pandemic. Courts may be more forgiving going forward when it comes to things like economic hardship caused by the pandemic than they historically have been. So in a lot of ways, we can only kind of predict what courts might do under the current circumstances. So force majeure clauses typically include events like wars, riots, labor strikes, natural disasters. These are all things that you might typically see in a contract. There might also be some vaguer concepts called out like acts of God or acts of government. Some clauses do include specific language around pandemics or medical epidemics, is the phrase you might otherwise see. It would be hard to argue that if you had that specific language in a contract that we don't have that going on here. Do keep in mind that even if you have a force majeure clause that might have some applicability here, contracts might exempt certain things from the operation of a force majeure clause. Rental payments, for example, could be an item that are specifically carved out of a force majeure clause, and that even if you've got applicable language, you're not going to be able to argue force majeure for those types of things. An easy example of how a force majeure clause might operate here would be for an event contract. So if you have an event contract to put on a conference for 5,000 people, and the conference is taking place in a state where the governor has issued an order prohibiting gatherings of more than 10 people, performance is now impossible under the contract. If you've got an operative force majeure clause, you might have a good argument that force majeure is preventing performance there. In terms of whether force majeure is going to apply when you don't have language specifically addressing a pandemic or an epidemic, it's really unclear. At least in Alabama, courts are going to strictly construe force majeure clauses to try and honor the party's intention at the time of contracting. So if your clause doesn't include language around a pandemic or epidemic, you will likely have a hard time arguing that you've got a force majeure event going on. If you do think that you are in a situation where you might be able to argue force majeure under a contract, there are a few things that you need to do right off the bat. First, you need to start documenting how you are responding to the current crisis, what steps you're taking to mitigate the impact to your business, demonstrating the hardship, because generally speaking, even if you do have a force majeure event, you still are going to have to demonstrate that you are not able to perform. So you're going to have to make that showing regardless of whether you've got an event that might be triggering the clause. A force majeure clause is not a get out of jail free card. You still kind of have to demonstrate why performance is impracticable. If you don't have a force majeure clause at all, or if you don't have language in a force majeure clause that's applicable here, there are some common law remedies that you might be able to take advantage of. There are legal concepts like impossibility, impracticability, frustration of purpose that might all serve to defend non-performance of a contract. And these are all sliding scale concepts that are really going to uniquely apply to parties in different ways. But, you know, just like with force majeure clauses that do include pandemic language, the case law on construing those clauses for events like what we're experiencing right now is really scarce. I mean, it's either non-existent or it's very limited. And so there is a lot of uncertainty in the legal industry right now as to how courts are going to treat performance in light of the current circumstances. You know, so again, if you are faced with a situation where performance has been made difficult, the best thing to do is to start documenting the impact on your business and really start talking to your business partners, whether it's a customer, you know, a tenant, a supplier, a vendor. By the time you were in a position where you were trying to argue force majeure, you know, the wheels have really fallen off of negotiations. In light of the legal uncertainty and the fact that everyone's kind of in the same boat in terms of trying to navigate what's really an unprecedented event across industries, the best thing to do would be to, you know, work with your business partners, try to come up with a solution either informally or try to reform the contract in a way that's going to allow both parties to achieve at least some level of performance until hopefully things go back to normal as much as they can expect it to be. You know, this is really going to be perhaps a brave new world of contract negotiation, both with current contracts and contracts going forward. So like I said, I mean, there's going to be a lot of trying to figure out solutions in a way that parties have really not had to do to date. So it's going to be very interesting to see the impact on, you know, on contract development going forward and on negotiations.
Great. Thank you, Sarah. I appreciate that. Next, we're going to turn to Mel. Did we lose Mel?
No, Mel's here.
Oh, there you go. We're going to turn to Mel, who's going to talk about landlord relationship issues and positioning your asset for a post-pandemic economy.
Thank you. Yes, my name is Mel McElroy, and spend a lot of time representing ownership groups across several asset classes. And over the past 6 weeks, we've been dealing with a number of issues with tenants in retail assets, office and industrial assets, multifamily assets, really across the board, because it is affecting everyone in different ways. And we've been formulating different ways to respond to the various situations that tenants of these types of properties are in. And what I would say to everyone listening is that there really isn't a one size fits all solution. It's going to be very fact specific based on the terms of the lease, the particulars surrounding a given tenant, factors, their past performance, looking forward, et cetera, which I'll kind of run through. I know there's been some specific questions that have been passed along, but I think what I'm going to try to do is give you kind of a framework today through which to analyze a particular situation you might encounter that's kind of from the landlord perspective, and that what we've been helping our clients with over the past few weeks as they look at this. The one thing that I think is close to a universal in the landlord-tenant relationship, and Sarah noted this, is in the force majeure context. While those clauses are present in leases, it is very, very unusual for that type of clause to let a tenant out of their rent obligation. So, most leases are fairly landlord friendly, and to the extent they do have a force majeure clause, they're typically going to exclude the obligation to pay rent from the operation of that force majeure clause. So when tenants have been reaching out to landlords regarding rent abatements, rent deferrals, rent holidays, et cetera, in most situations, a landlord is going to be able to respond with some relative negotiating leverage based on the terms of the lease. So just from a outline, the first thing you really need to do as a landlord is read carefully the terms of your lease. Certainly look at the force majeure provisions. Look for any other tenant rights that might be out there, such as a right to terminate at a certain period of time during the lease. If there's a co-tenancy provision, if it's a retail lease, where typically what that means is if you're a tenant and in your lease it says that for example, if you're a restaurant operating next to a grocery store, if the grocery store closes, I don't have to operate. So that's a co-tenancy clause. So if you're a landlord, you look to see if that's available. Anything in the lease that might give the tenant an opportunity to avoid its obligations outside of a force majeure type provision. So you want to really understand that. You also want to really understand what forms of credit support you have on a lease. So that means, is there a lease guarantee signed by either an individual or a parent company that has substantial net worth or assets to back the lease? So understanding what your position is there. Now, before you go and respond to a tenant's request for some sort of relief, you also need to understand your loan documents to the extent you have a mortgage loan that encumbers your property. Depending on the type of asset and the type of loan, you may have restrictions on the types of amendments and actions you can take with respect to a tenant. So you need to review carefully those loan document provisions and understand what limitations you may have. Some loans are going to give landlords the ability to operate and manage their tenants and leases as they see fit. Others are going to require certain permissions. If you're in a situation that requires consent from a lender, you need to engage in conversations with that lender to find out what flexibility they are going to be willing to offer you in dealing with those tenants, because that's certainly going to inform how you respond in each situation. In addition to the loan, also in your loan documents, you need to be thinking down the road in terms of your access to capital. We don't know what this is going to look like in 6 months, 9 months, and so to the extent you are able to manage cash flow and avoid having to postpone or defer or default on loan payments, that is going to be to your advantage down the road. So that's also a consideration as you think through and manage your response to the various tenants that are coming through. And then, really understand your property's cash flow position, the amount of income you need in order to cover basic operating expenses and debt service, because that's going to give you some idea of where you can afford to provide relief to tenants. Because really, this all comes down to kind of managing the short-term pain to really put your asset in a position for the tenants to really rebound once the restrictions lift out there and the economy is able to resume operating at full speed again. So really understanding where that line is for you, so So once you've kind of got a sense of what tenant rights and assets they have behind their leases, what flexibility or permission you have under your loan, and where you need to be, then you can really begin to evaluate the various requests you may be getting from tenants. One side note here, there's been a lot of talk about business interruption insurance. Most casualty policies that a landlord would carry would have a type of either rental loss or business income insurance provisions or insurance coverages. And there was a lot of interest in, are these coverages going to help landlords in these situations? And that's kind of to be determined. I will say at a high level, most in response to the MERS and SARS viruses, a lot of these types of coverages included an exclusion for a specific exclusion for virus and bacteria, microbe related events. Generally speaking, if that exclusion is in your policy, then business income or business interruption insurance proceeds are likely not going to be available. Some policies do not include that exclusion, and there may be an avenue to recovery there. So it's something you should take a look at and not discount that. But there are some hurdles to overcome, because most of those business rental loss, business interruption are tied to a type of physical damage to the property or to an adjacent property. And so if that is not present, that kind of creates an obstacle to overcome. Certainly there are people out there looking at ways to obtain coverage under business interruption insurance. It's something you should look at. But as general, we are kind of telling people not to rely on that because it's more than likely going to require a push on the claim side. So as depending on the type of asset you have, you're probably getting a lot of requests for relief. We've certainly seen assets where we know tenants didn't need it and they sent in relief request anyway. So you've kind of got to triage that and manage how you're going to respond. So, there's two kind of principal ways to think about it that people have taken. One is really to do nothing, politely decline through a letter or other correspondence, and then let a tenant that is in a position that they feel like to have to default, and understand that they will kind of negotiate with them down the road. And the idea being to preserve leverage going forward in that event. The other response is to go ahead and try to work out some type of forbearance, deferral, amendment type of scenario where you're going to give them permission to typically defer rent, not abate or eliminate a rent obligation altogether, but to defer it down the road. So those are kind of the two main responses that we would be seeing. Eviction, you probably heard, it would be, some jurisdictions have flat out banned eviction proceedings for the moment. Others, it's probably not going to be terribly well received. So we're kind of setting aside an eviction proceeding at the moment. But the one other option would be to go ahead and sue or to terminate a lease. The scenarios where that is happening is primarily where a tenant was sort of non-performing going into this, and the prospects for coming out on the backside are not good. And it may be beneficial to go ahead and terminate the lease and ask them to vacate so that you're in a better position and aren't subject to, for example, a stay in bankruptcy if that tenant filed for bankruptcy. So going back to our two main options there, which were kind of do nothing, preserve our rights, or say no, reserve our rights, or go ahead and enter into an amendment. The things to think about really are, first, each asset class is different. So looking at, is it retail, is it office, is it industrial? Retail, as you can appreciate, has been hit really hard and has been hit really immediate. So most of the deferral arrangements we are seeing are centered on retail. In the office and industrial space, and really the multifamily space too, the rents for April and May seem to be holding up. It's anticipated that the defaults, to the extent they are going to occur, are going to come a little later as the effects of the economy begin to spread further. So really, in the office scenario, though, the one exception to that you were seeing is medical and dental offices, because those offices have been prohibited from operating in a number of jurisdictions, certainly in Alabama. And so those are areas where landlords have been looking at those scenarios with more openness to work out an arrangement. So, but retail hardest hit. I mean, from April, the landlords across the country have been reporting between 50 and 70% income coming in. That will probably get worse in May. So those tenants are where a lot of the focus has been. In office and industrial, you're kind of seeing landlords say, not yet, or we'll hold off. The next thing, if you're looking at tenants, you really need to make sure you're looking at the distinction between the essential and non-essential businesses. Certainly if a grocery store, pharmacy, hardware store that have been open and are doing a solid business, that's not where you're going to want to spend any rent relief. That's a place to, obtain and preserve cash flow as you go in. Food tenants, some of those are doing okay through the curbside and delivery services. The areas that have been hit the hardest are certainly the non-food, non-essential retail goods. So your clothing stores, et cetera. Those have been hit the hardest, and those really aren't able to generate income. And so that's probably in the retail space where you're seeing a lot of focus. Food too, but certainly those are going to be the hardest hit. And then within that, I would also consider, is this a local small business, family-owned business? Is it a franchisee? Even though it may be a national brand or franchise, it could be owned and operated by a local franchisee who only owns a handful of stores and is feeling that directly. Landlords tend to be giving priority for rent relief to those types of tenants over national credit tenant operations. And the main idea there is just access to capital and balance sheets that can better position them to ride out a window of disruption. And then finally, mentioned this earlier, is understanding what credit support is there behind those obligations. A big thing to look at is a security deposit and whether that exists, and whether there are also some deals, some leases are secured by letters of credit. So understanding, is there cash at hand that can be used to satisfy rent obligations in the short term? And so if you kind of get into a situation where you've got a tenant that you determine needs it, and one thing most landlords are doing is asking tenants that are applying for rent relief to demonstrate their need, providing sales numbers. Are they closed? Are they required to close? What have they done in terms of employees? What have they done in terms of trying to mitigate their own damages? Have you applied for the various assistance programs, such as the PPP loan program? And having them demonstrate their efforts to manage the crisis and the alternate sources of liquidity that they need. So you want to require and look at all of those in connection with these requests. So finally, once you've kind of figured out where you can, what is the amount of relief you can afford to grant to keep the lights on, keep the property running, keep your lender satisfied, then you're kind of prioritizing that toward those tenants, that kind of fall into that highest need bucket. And that, you really are going to need it to be able to come out of this and rebound when shopping and traffic is able to begin to look normal again. And so when we have then gotten down the road with those tenants, what that has typically looked like is a short amendment to their lease, rent that is due is typically being deferred for a period of time. What we're seeing is 60 and 90 days typically, with, what we like to do is give the option to the landlord to extend that. Preferably, the tenant would continue to pay basic operating expenses, taxes, common area maintenance, insurance. So your operating expenses are covered, but you're deferring the base rent portion of their obligation. And, we are expressly calling it a deferral, not an abatement. And what happens then is you structure the repayment of that deferral either through adding an equivalent amount of term to the end of the lease, or by amortizing that amount over 12 months, 18 months, whatever you're able to agree to. One thing, as I mentioned earlier, that a lot of that landlords are looking to do is to go ahead and apply any security deposit that is out there toward, say April or May rent. And then part of that lease amendment then is for the tenant to replenish that security deposit, letter of credit proceeds, either immediately or over time as you resume operations.
No, we've got about 30 seconds.
Okay, I'll wrap this up quickly. The last couple things to think about in those amendments are to also require that if they do get a PP loan or other assistance programs, that they are using that to help pay rent. You want to work that concept there. Also make sure there is a confidentiality provision so that the tenants aren't talking about the deal you cut with them across. And then in some situations, especially larger national credit tenant type scenarios, it may make sense to also whatever deferral you can do, try to see if there are other negative provisions in the lease that you may want to modify or eliminate going forward, such as a termination option during that scenario. So that's kind of the framework as you look at a landlord from the landlord side of the tenant relief request. The last thing I'll mention is just to stay on top of legislative actions going forward. Those may impact tenant obligations, landlord obligations, insurance, et cetera. So stay abreast of those as they come up.
Great. Thank you, Mel. Appreciate that. Now we're going to go to Brad Siegel, who's going to talk about tenant relationship.
All right, I appreciate it. This is going to be a little kind of the mirror image of what Mel was talking about a minute ago. And what I'm going to try to do kind of briefly is just go through the different property types like we were talking about before. So starting with multifamily, if you're a tenant in a multifamily kind of a complex, there are some governmental rules that were enacted that help you. So most states have enacted a deal that you can't be evicted right now. There are laws that do it. There are also some federal laws in connection with the CARES Act that were done. For example, if you have a federally backed loan, there's some prohibitions against eviction for non-payment of rent. This is temporary. It's not an abatement. It's more just you can't be evicted if you don't pay. What it really kind of gets back to is if you're able to pay, please do. And then the problem becomes, what do you do at the end? There is no solution to this. It just says for right now, you can't evict on the multifamily basis. In the office side, as Mel was talking about earlier, there really hasn't been quite the mega impact that we've seen at the retail level. From the multifamily side, again, with all the unemployment, it does have an impact. On the office side, it appears that, based on the percentages that are out there, most of the office tenants, at least for right now, have not been severely negatively impacted. But there are also not really any big federal rules that are out there to protect the office or industrial tenant. The things that Sarah was talking about earlier about force majeure. So what we're going to get to, and we're going to talk about it mostly in the retail setting, just because that's where the major impact has happened. But the first thing you do and the last thing you do is you read your lease. At the end of the day, this all comes down to what is the contract you signed, what does it say, and what are the rules? While there may be some help from a governmental perspective, whether it's federal or state, at the end of the day, the contract you signed is the contract that we have to live with. So for each setting, there's probably going to be a different answer because every lease is different. And the multifamily side, that's the one aspect of that is those are not really negotiable. You get presented a lease, you sign it, and that's your deal. Very landlord favorable. Office setting, you do get to negotiate a lot of the provisions in there. So it's at least worth checking to see on the office side, what are some of the rules? For example, if the building has to operate? Is the landlord having to shut the building down? So if you're a tenant and there's issues about whether the building's been open or closed, it's definitely worth paying attention to. On the retail side, which is again the aspect that a lot of the questions have come out from y'all on, as well as that we're trying to answer just by the presentation today, there's a lot of impact on all the different kind of goods that were out there. There were soft goods, shopping, entertainment, personal services, all the different things have had a little bit of a different impact. If you're a grocery store, a pharmacy, or a supplier of food, you probably are not as impacted negatively as if you're any of these other personal service businesses, hair and nail salons, et cetera. So the first thing we do, like we talked about, is review our lease. What does our lease say and what's our position? So what Mel was talking about earlier was, here are the things that the landlord needs to make sure of to protect the property, to deal with their lender, and to make sure things are status quo from the different perspectives you have as the owner. If you're the tenant, you kind of have to know where you are. In other words, what does my agreement say? What does my lease say? And to the extent that there are any statutory things that are passed, it's worth reading. But for right now, there's very little of that. So we signed a lease. That's the first place we start. For example, in helping a retail tenant, there's a lot of things that you want to look at from a negotiating perspective. So what most of the things that are happening, because it's in being in unprecedented times, we're not super clear on, does the landlord not want this tenant? So a couple of the questions that were posed earlier were, the landlord had talked to me about leaving and things like that. So the question becomes really, where are you as the tenant in your position? So before you get to the negotiating place, or I know I'm not going to be able to make my rent payment, my May payment, for example, let's look at the lease and see where we are. For example, some of the things you want to look at are, what are some of the obligations of the landlord? In the lease, for example, does it say that they have to operate, and I'm using my quotes since you can't see me and I'm not standing in front of you, the shopping center or the building that you're in? Because if there's some operations clause, you may have an ability to say that they haven't provided me the items that I need to control my circumstances and operate my business, because they're just not operating the center. It could be because of what people are arguing is a force majeure, or because the state shut down, but that's at least one of the things we're looking at. The second thing in your lease that's probably there, depending upon how it was negotiated on a more or less limited basis, are representations of the landlord. Did you get reps from the landlord in the lease that are maybe helpful in something that's going on now? Very little of leases in this circumstance that I've seen so far have dealt with the pandemic or epidemic, but it's at least worth reading. One of the things that Mel had talked about earlier was co-tenancy. And so if you're a tenant that has a co-tenancy clause that the large grocery store has to be open for me to stay open, or a certain percentage of tenants within the center have to be open for you to stay open, you may have some rent relief or remedy there, just depending upon whether it's in your lease or not. The other one is some kind of a kick-out clause that you may have that allows early termination for certain circumstances. So it's definitely worth looking at those as well. In the force majeure, like Sarah and Mel both talked about, the courts tend to read these clauses very, very narrowly. So I wouldn't bank on that as being the way out. It's probably better to look at the other alternatives that we were talking about earlier. And I would just be careful, because like I said, the force majeure is going to be narrowly interpreted. So what are some of the risks if you're the tenant? First of all, did you sign a guarantee? Is there somebody out there that's personally on the hook to the landlord to make payments whether or not the business is operating? So that's I'll call this in the SWOT analysis, that's in the bad column. Are there operating covenants that we agreed to as a tenant? Do we agree that we're going to continuously operate? These clauses are in lots of leases. And if you're a tenant that signs kind of the standard form off the shelf lease, there's probably an operating covenant that you're agreeing to operate your business. Now, what Mel talked about earlier was, it's not in the best interest of the landlord necessarily to try to kind of go after or commandeer tenants' money, but at least that's something to look at. The other thing to look at in your lease is, how are you paying your rent? Are you paying it just triple net lease, where you just make your rent payments every month plus CAM and taxes and insurance? Are you on a percentage of sales? Particularly if you're not selling anything, obviously that changes how the rent's done. And then the other question is, some answers that tenants may have is, do you have a lender? Did the tenant borrow money for certain circumstances where to buy equipment, to buy goods and services that you're selling. So you may have to look to your loan documents as well to determine what your rules are with your lender. So everybody's got to talk to each other, which gets us to the solutions. So the question becomes, in a lot of circumstances, does the landlord need the tenant? Does the tenant need the landlord more? Who's in a better position to bargain? In the multifamily, the non-payment of rent is about the only solution. And we've talked about that, and that's been discussed and solved, at least temporarily. There are some large national tenants that are sending out letters that are saying, let me defer rent. And then when the time comes and I can open back up, I'll catch back up, whether it's through a deferral or some kind of makeup of the rent or extension of the lease. Another alternative that's out there that I think we touched on is tenants just paying some form of CAM taxes and insurance just because the building still has to operate. They still have to cut the grass and sweep the parking lot, and there are things that have to happen because there are certain businesses that are open. And so some tenants may think of a solution of, let me just pay the basics until I can get through and not pay rent because I'm not selling any shirts or couches right now. So that may be an alternative. A last alternative, but that's happening now, and one of the major retailers that happened to the other day is J. Crew filed bankruptcy. And so, we have professionals here. That is not my topic of expertise, so I won't discuss it, but there are solutions within the bankruptcy realm where it's not closing down your business and shutting down, but it does give you the ability, if there are multiple locations, to potentially reject a lease or change some terms. So tenants have a little bit of power, if you want to call it that, much less than a landlord would, but at least it gives you some bargaining position. Hopefully these answered some of the questions that you've been looking to. We're all trying to take a little bit of time and talk about these topics. There are myriads of issues that we can discuss, but before we get into a lot of these, what I would think about, at least from my end, is non-payment of rent versus a deferral. Typically there are lenders involved, so you have to think about the solutions that everybody has. And what we're seeing is a lot of landlords and tenants are getting along pretty well in terms of working something out, because being in unprecedented times, there's no, what did you do like this when it happened the last time? Because it hasn't happened to us in our circumstance. Finally, the one thing I wanted to touch on, and this is just going to be a 1-minute thing, and it's basically to introduce Lee Shepard too. A lot of the same things that we've talked about in the lease arena are happening in the purchase and sale arena. So if you're trying to buy land or improve property, a lot of the things on your timing have typically been put in questioning times, basically. The surveyor can't get a survey done because there's a stay-at-home order. The zoning company can't get a zoning report done. There's inability to do things as quickly as we have done them in the past. And most of the contracts don't really have time extensions built in for things like this. So a lot of what we've seen in the purchase and sale arena has been working together with your seller and or buyer to do the same thing. For example, and this will lead a little bit into Lee's construction item, if you're buying an out parcel of a shopping center, a lot of the things that pop up are timing to build whatever your building is. So you're going to buy this out parcel at a center, and your timing is, I agree, I'm going to construct whatever building I'm going to build within 36 months. Well, a lot of those timetables have gone out the window. So it's really come into play in the construction arena as well. Again, lots of topics on this. I'm very pleased to have talked to y'all. And I know Lee will deal with a lot of the things that we had talked about as well.
Thank you, Brad. Really appreciate it. Lee is going to give us some insights on construction.
Thanks, Lauren. Can you hear me?
Mm-hmm. Yep.
Okay. So it's good to be with everyone today. As with the other areas, landlord tenant, that have been discussed, COVID-19 is definitely having an impact on the construction industry, with construction projects worldwide and in Alabama as well, experiencing various levels of stress, including general labor-related issues, labor supply issues, supply chain challenges, and financing pressures as well, similar to what Brad and Mel talked about on the financing side. All these issues create challenges for both owners and contractors. And I know we've probably got a number of different industries on this webinar today, owners and contractors and developers, engineers. And so I'm not really going to focus on one side or the other, but really kind of issue spot. Essentially and ultimately, the issues that are being experienced in the construction world and on construction projects put pressure on really one primary thing, and Brad alluded to it, and that is timing. And anyone who's either been involved in a construction project, if you're an owner, if you're a developer, if you're a contractor, you all know very, very well that timing is an essential and fundamental element of any sort of construction project. And when timing is disrupted, it creates issues on your construction project. And that's what we're seeing a lot of right now, is the disruption of that fundamental element of time. Many states, this has already been mentioned, including Alabama, have deemed most construction and related services to be essential services, which basically excludes or exempts them from a lot of your stay at home or your shelter in place orders. That does not mean, though, as I've already alluded to, that construction projects are not experiencing issues. And that doesn't mean that they won't continue to experience some issues just because they are able to go to work and continue their projects, because you are seeing, unlike a lot of businesses, construction projects in many cases are continuing to move forward. It's the manner in which they're moving forward that has shifted a little bit. And so if you've just begun, or you are currently in a construction project, or you're about to begin a construction project, what are some of the things that you need to be thinking about, and what are some of the things that you need to consider? And so what I thought I would do is just spend some time going through some of the issues that you need to be thinking about. And as with my fellow fine colleagues, where do we start? As any good lawyer would tell you, you start with a review of your contract. So you start with a review of your construction contract that either you already have in place or you are about to negotiate. And you review that with an eye towards identifying and assessing relevant provisions that may be impacted by COVID-19. Like any other sort of contract, construction project contracts are all over the board. You've got super detailed contracts. You've got contracts that are general and short. You've got contracts, the AIA form, the American Institute of Architects, that is, a form that is used by many of your professionals throughout the industry. But even that contract is modified, and it's routinely modified. So you need to really review it and review your contract for crucial provisions that are hopefully included and really need to be understood. So let's go through just a few of those, and I'll point those out and give you some kind of general thoughts about and how they are being impacted. I don't want to beat a dead horse, but force majeure is actually a fairly significant issue in construction contracts. And as Sarah has mentioned, force majeure provisions can be all over the board, and they come in many shapes and sizes. Again, not to continue to go down that road, but I would just leave it at this. The devil is truly in the details on a force majeure provision, and that applies to construction projects as well. And I actually think a lot of case law will stem from this current time period that hopefully will better inform us down the road as to how courts will interpret force majeure provisions. But I will mention in the construction context, sometimes there's kind of some additional issues that might be added to a force majeure provision. Sometimes you'll see a requirement in there that the Delaine event actually impact the critical path of the construction project. So a lot of times there's kind of a direct impact or a direct corollary that is built into some of those again, read the provision because the devil is really, again, in the details there. I think that you always need to look at your contract for provisions that relate to timing in particular. As I mentioned, timing is very, very important. And, you know, there's a number of places within a construction contract. Most construction contracts have an actual contract time by which the project is supposed to be substantially complete or complete. And so it's important to review and look at, what does substantial completion mean? How is it defined in your construction contract? And the reason why I bring that up is, you know, many times a substantial completion definition in a construction contract will include a requirement that a certificate of occupancy be issued by the applicable governmental entity. Well, as Brad mentioned, you know, what if in your venue, the office that issues and inspects projects for the issuance of certificates of occupancy is delayed? What if it's closed? What if it's precluded by law from getting out there and doing anything? That can then impact whether a contractor is deemed to be in compliance with their contract or not. So that's one of the things that you want to look at. And then along the same lines that Brad mentioned, you know, what about the issuance of permits? All projects need permits in place before they can even begin. Some of your construction contracts will actually state that the contract time does not begin until the permits are issued. That gives you a little bit more flexibility. What if the contract time begins from the date you sign it, and all of a sudden your contractor is delayed in getting their permits and their own time frame by which they've got to get it completed? So that's another timing related issue that can impact a project. Just delays in general. Delays are always a big issue in any construction project, but in particular in this environment, they are really at the forefront, and a question that we're getting a good bit. So I just would say, look to your contract and see how delays are addressed. You know, what delays are deemed to be excusable delays under your contract, and what delays are not deemed to be excusable. You know, many of the delays that we're seeing and we're getting questions about on ongoing projects is not a result of your general contractor, or even, you know, a lot of times your large subcontractors dropping the ball. They're doing what they can. They're trying to move the project along as best they can, but there's supply chain issues. And you know, if a material or an equipment supplier is delayed, or is unable to manufacture the material or the product that they're supposed to deliver in connection with the product, that's going to cause an impact on your project. You know, what if they're in a state that has a strict order in place where they can't actually operate? What if materials are coming from across the ocean, from a country that's, you know, impacted more heavily than we are, or has different laws in place? All these sorts of things have a trickle down effect, or I guess you call it a trickle up effect, on your project. So that's where we're seeing a majority of delays come from, though, again, is on the material and the supply chain side of things. Notice requirements. What are the notice requirements that are related to claims for delays and force majeure? And I think Sarah mentioned this as well. And when I say claim, I say a formal claim, whereby a contractor is making a formal claim for an extension of the contract for a delay that they can't control. Just want to mention one thing. We're seeing a lot of generic notices go out in connection with projects. And when I say generic, I mean notices that are sent out by a contractor or by a subcontractor saying, hey, heads up, we think there may be a delay, or we think there may be a force majeure event that will occur as a result of COVID-19. They aren't actually providing specifics or making an actual claim stating there's been a delay or making a claim for force majeure. They're almost just putting you on notice, which is not the same. So I would just advise you, when you get notices relating to things like that, read them closely, read the provisions in your contracts to determine Number one, does it fit the definition of a notice? And number two, does it require a response from me to reserve my rights as well? Generally speaking, it's best to respond to something like that, whether you deem it to be a formal claim for delay or force majeure or not, just to make sure that you are keeping things of record. Real quickly on that front too, do delay claims allow for extensions of time? Do they allow for additional fees and costs to be paid to the contractor, or maybe even both? So it's important to consider that as well. Whether a delay gives the contractor additional time to finish the project, or likewise gives them additional compensation. And if additional costs and expenses can be incurred, what types of costs are actually compensable? So it's important to look at those provisions as well. And then finally, kind of the last issue I thought I would bring up is just look at termination, delay, and and suspension clauses. Do either party have the right to suspend or terminate the project for convenience or for otherwise? Most contracts, in particular your AIA forms, do have a provision that allows owners the right to suspend or terminate the project for their convenience. Now, it may be that there's an additional cost associated with that, but there is typically that right in a contract, again, on an AIA form, that gives you the ability to kind of put the project on hold for a little while and let's see what happens with this thing. Again, there's costs usually associated with that, so make sure that you look at that issue. Likewise, it allows for contractors to terminate if an owner tries to suspend a contract for too long. Usually there's a 60 to 90-day provision that'll allow the owner to suspend it. If they continue to go past that, sometimes it gives the contractor the right to say, sayonara, I'm terminating and moving on. So those provisions I think are really, really important. And that's kind of a big picture assessment of just provisions and issues that are being impacted on construction projects. Again, read your contract and assess your risk there. The last thing I wanted to say, and I think Sarah mentioned this as well, that I think is just uber important, and that is communication. I don't think it's a great idea just to fire off a letter to your owner or to your contractor about, hey, we're experiencing this. I think communication between owners and contractors is very, very important in this environment, because unlike, I think, past instances of contract disputes, this is an issue that both parties are experiencing, and COVID-19 is impacting both sides. It's not just one party trying to hide behind a rock and trying to use it as an excuse. I'm not saying that doesn't happen, but it's important for owners and contractors to identify areas of the project, whether you're about to start one or you're in the middle of one, that are likely to be impacted, and determine the ways to best mitigate the disruptions and the possible disruptions that might come about from that impact. I think the primary objective needs to be the completion of the project within or as close to the original schedule as both parties set out, and within or as close to the original budget as both parties originally established for the project. So again, I think communication, and even upping your communication. If you were previously meeting with your contractor, if you were previously meeting with your owner once every 2 weeks, step it up to a week every week, because as we all know, this environment is shifting and changing really quickly, and those fast change in the market and the supply chains can quickly have an impact on the timing element of your construction project, which I mentioned from the onset is really the true, fundamental foundation of any sort of project. And that's all I have.
Lee, thank you very, very much. That was great. We're going to finalize things with Sarah, who's going to give us an update on cybersecurity.
Thanks, Lauren. This will be really quick, guys. I just wanted to provide some insight into what we're seeing on the cybersecurity front. We have definitely seen an uptick in cybersecurity incidents. Cyber criminals are certainly taking advantage of folks whose workforces are working from home and remotely working and maybe not paying as close attention as they normally do under normal circumstances. The one fraudulent scheme I wanted to highlight for this audience specifically is what's called a fraudulent invoice scheme. And that involves cyber criminals compromising someone's email account, whether it's yours or your business partner, supplier, customer, whoever it may be, and sending out a fake invoice that redirects payment to a new bank account, which is the criminal's bank account. So they're asking for a change in wiring instructions, and they are emphasizing, taking advantage of current circumstances, emphasizing the need to get paid timely under the current economic environment. And unfortunately, we're seeing folks fall for that scheme pretty frequently. A couple of things to keep in mind if with respect to fraudulent wire transfers or fraudulent ACH transfers. Once you send out a fraudulent wire or ACH payment, if you alert federal law enforcement, they can stop the payment from hitting the attacker's bank account within 72 hours. After that point, there is very little chance the money can be recovered. You might have insurance coverage for fraudulent payments under a crime policy or perhaps a cyber liability policy, but the devil's going to be in the details with those policies in terms of what's going to be included. Some general tips for good cyber hygiene during this time. Remind all your users not to respond to a request to change wiring instructions without picking up the phone and verifying the legitimacy of that request. That's usually all it takes to recognize a fraudulent scheme as it's happening. If you are a business that sends out invoices to be paid, consider putting language in the email signatures of your AR folks or other folks involved in the finance department that warns recipients not to respond to a change in wire instructions from you via email. Again, that's usually all it takes to put people on high alert. You should always have multiple levels of approvals for wire transfers or ACH payments. That's the best practice regardless of the circumstances. And then just take this opportunity to brush up on your email security generally, review your password policies, consider going ahead and asking for a password change if it's been a while. Turn on multi-factor or two-factor authentication for remote access to email into your network if that's possible. That's one of the best ways to prevent email accounts from being hacked, which is usually the way that these fraudulent invoice schemes are happening. So just a quick update. The key is just to be aware of the threats that are going on, and that's usually enough to have people stop and pause before doing something that might impact the company negatively, either financially or reputationally.
That's great information. Thank you, Sarah. Really appreciate that that addition to the program. And that's all we have. Thank you again to all of our experts from Manor, Cooper, and Gail. And thank you to all of us that joined this afternoon. We hope we are walking away with some really valuable information that you can use. A reminder that both the BBA and Manor Cooper both have COVID-19 resource pages on their website, birminghambusinessalliance.com and manorcooper.com. And if you need clarification on anything that you heard today or have a follow-up question, visit the BBA's website on the resource page and hit the Ask a Question tab to submit something. Thank you all again for the great information and your time, and thank you for everybody for joining us today.
Thank you
For having us.
Thanks. Appreciate it.